They didn't ban a gun. They erased a 90-year federal gun tax, and the system behind it is starting to shake. Here's what nobody is saying out loud. That tax wasn't just money. It was the legal anchor for an entire enforcement regime. Fees, approvals, delays, registration, the whole pipeline. And the moment Congress pulled it, some backlogs vanished almost overnight. So you have to ask, were the delays real or were they leverage? Now, Washington is in panic mode because if the tax is gone, a question hits like a hammer. What's left to justify the rules that depended on it? That's why lawmakers are already floating a replacement, not $200, something closer to $5,500, the highest price tag ever aimed at a constitutional right. And they want it buried in a must-pass bill, timed to force compliance. Meanwhile, judges aren't waiting. Agencies want the courts to stall because they're betting Congress can rebuild the foundation before a ruling shatters it. And here's the part that should worry. This isn't only about what you might buy next. It's about what you already own and whether new fees get used like a retroactive punishment. So the real fight isn't guns. It's power. Who gets to regulate, through law or through price? And the next procedural move by Congress or the courts will answer one brutal question. Did Washington just lose control, or are they about to take it back in disguise? Congress quietly ended a 90-year federal gun tax, and Washington's response could decide whether it survives at all. In a move that caught many observers off guard, Congress recently and discreetly included language in a legislative package that effectively eliminated federal tax dating back 90 years. Specifically, the levy imposed under the 1934 National Firearms Act. And the sudden void has initiated a frantic, high-stakes political conflict in Washington, where legislative and legal maneuvers are now underway that will determine if this historic rollback remains intact or is immediately overwritten by even stricter regulations. A historic rollback of firearm restrictions just passed, and within days, a counterattack was already in motion. The passage of the measure, seen by Second Amendment advocates as a monumental and necessary correction to decades of policy, instantly triggered an aggressive, coordinated counterattack from gun control proponents, who are racing the clock to introduce new legislative measures and legal challenges designed not only to restore the lost revenue stream, but to dramatically escalate the cost and complexity of acquiring regulated firearms, fundamentally reshaping the future of gun policy in the United States. For the first time since 1934, a core pillar of the National Firearms Act has collapsed, and the fallout is spreading fast. Since its enactment during the height of the Great Depression, the National Firearms Act, NFA, has relied heavily on the transfer tax as a mechanism for registration and regulation, and the sudden elimination of this core financial pillar has caused an unprecedented regulatory collapse, with immediate operational fallout affecting the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, and creating a cascading effect across the entire federal framework governing suppressors, short-barreled rifles, and certain destructive devices. This wasn't a temporary budget trick. Congress permanently shut down a major federal gun tax, and agencies are scrambling. The legislative action taken was definitive, establishing a permanent cessation of a substantial federal revenue source that historically supported the administration and enforcement of the NFA, leading to widespread confusion and intense activity within federal agencies, which are now scrambling to reevaluate their operational mandates, funding structures, and the legal basis for maintaining millions of firearm records without the tax mechanism that previously justified their collection. One vote just erased a decades-old ATF revenue stream, and now lawmakers are racing to rebuild it at record levels. The successful passage of the repeal amendment, achieved through a crucial, often overlooked vote, instantaneously dried up a dedicated revenue stream that the ATF had relied upon for decades to to fund regulatory compliance, prompting a desperate legislative effort by opponents who are now drafting emergency proposals that would not merely reinstate the tax, but increase it exponentially to historic punishing levels, intended to severely restrict access to NFA items. The most significant federal firearms rollback in generations has triggered an immediate power struggle in Washington. This unexpected and profound shift in federal firearms policy, the most impactful regulatory rollback seen in decades, has ignited a deeply entrenched power struggle within the Capitol, pitting dedicated gun rights organizations against well-funded advocacy groups and key congressional leaders, all vying to define the new legal landscape, with the ultimate outcome likely determined by who can successfully leverage procedural tactics and court challenges first. A law meant to end a tax has instead exposed cracks in the entire federal firearms regulatory system. While the immediate objective of the new law was limited to eliminating the costly NFA transfer tax, the unanticipated consequence has been the immediate exposure of fundamental legal and administrative vulnerabilities across the entire regulatory infrastructure, revealing that the federal government's authority to mandate registration and monitor ownership was far more dependent on the existence of that revenue measure than previously acknowledged, suggesting a profound legal fragility. A single legislative move just put hundreds of federal jobs, millions in funding, and a national registry in question. The legislative elimination of the tax has had tangible, immediate impacts, rendering the legal justification for hundreds of specialized federal positions obsolete and calling into question the budgetary allocation of millions of dollars, while perhaps most critically jeopardizing the integrity and continued operation of the decades-old National Registry of NFA items, an essential tool for law enforcement that is now facing an existential legal threat. What Congress eliminated wasn't just a tax. It was the legal foundation holding up an entire enforcement regime. Expert constitutional lawyers now widely agree that the NFA tax was not simply a financial measure, but the critical statutory mechanism that courts historically relied upon to justify the federal government's authority to regulate firearms under the Commerce Clause. By removing this legal foundation, Congress has inadvertently pulled the linchpin from an entire enforcement regime, immediately weakening the government's power to enforce registration mandates and leading to widespread challenges to existing regulations. Federal courts are now weighing arguments that could dismantle the National Firearms Act from the inside out. In the wake of the tax repeal, federal district and appellate courts are now rapidly accelerating their review of pending firearms cases, listening intently to new arguments positing that the National Firearms Act, stripped of its taxation authority, can no longer legally mandate registration under the existing constitutional precedent, presenting an unprecedented opportunity for legal advocates to dismantle key elements of the law through judicial review. Anti-gun lawmakers didn't wait long. Within days, a proposal surfaced to replace a $200 tax with a $5,500 one. The response from lawmakers advocating for stricter gun controls was swift and dramatically aggressive, eschewing gradual increases in favor of an extreme measure that surfaced within days of the repeal, introducing a replacement tax proposal that would skyrocket the current $200 NFA levy to an astonishing and prohibitive $5,500 per item, a move explicitly intended not to raise revenue, but to act as a catastrophic financial barrier to ownership. A revenue measure upheld in 1939 no longer collects revenue, and judges are openly questioning what that means. The legitimacy of the NFA was historically cemented by the Supreme Court's 1939 decision in United States v. Miller, which upheld the law largely on the grounds that it was a valid exercise of Congress's taxation power. Now that the core revenue-generating mechanism has been been intentionally disabled, judges across the federal judiciary are grappling with the profound constitutional implication of regulating firearms under a law that is no longer functionally a tax measure. The ATF is facing a crisis few Americans have heard about, and it's unfolding behind closed doors. While the public remains largely unaware of the procedural details, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, is currently navigating an internal and regulatory crisis of immense proportions, holding urgent, non-public meetings as the agency struggles to rationalize its continued operations and maintain its regulatory authority in the absence of the key tax provision that has anchored its jurisdiction for the last 9 decades. Processing delays vanished almost overnight, raising uncomfortable questions about why they existed in the first place. An immediate and highly visible consequence of the NFA tax elimination was the almost instantaneous disappearance of the multi-month processing delays that historically plagued the legal transfer of NFA items, a sudden shift that has raised pointed and uncomfortable questions among citizens and policymakers alike regarding the true administrative necessity and underlying regulatory intent behind the years-long backlog that was previously claimed as unavoidable. Hundreds of federal employees now have no clear legal function after Congress pulled the plug on NFA taxes. The cessation of the transfer tax has created an immediate bureaucratic redundancy, placing hundreds of federal employees who were primarily tasked with processing the tax forms, managing the subsequent revenue, and tracking tax compliance in a state of limbo, as their original tax-dependent functions are now nullified, prompting a significant internal review of personnel assignments and potentially leading to a large-scale reorganization of federal resources. A permanent tax ban just triggered one of the largest coordinated gun rights legal challenges in U.S. history. The congressional decision to permanently remove the NFA tax has provided a crucial legal opening that has immediately triggered a massive, highly coordinated legal mobilization among major gun rights organizations, who view the tax ban as the decisive moment to launch one of the most comprehensive constitutional challenges in American history, aimed at voiding the remaining registration and transfer mandates of the National Firearms Act. States representing over 100 million Americans are betting that removing the tax removes the Constitution's justification. Multiple state attorneys general, representing jurisdictions that encompass more than 100 million residents, are actively preparing or filing amicus briefs in federal courts, strategically arguing that since the legal justification for the NFA was rooted in Congress's power to tax, the intentional removal of the tax mechanism simultaneously eliminates the constitutional authority upon which the entire remaining regulatory framework of registration and possession rests. Judges in multiple circuits are signaling that long-standing registration rules may no longer be defensible. Reports from inside the federal judiciary indicate that judges presiding in several key circuits are now sending clear, albeit informal, signals of profound skepticism, openly questioning whether the government can legally justify maintaining the mandatory registration requirements for NFA items, suggesting that they may be poised to rule that these long-standing rules are no longer constitutionally defensible once separated from their original, explicit financial purpose. Lawmakers say the tax and registration were inseparable, yet the Justice Department is arguing otherwise. In an increasingly complex legal debate, key lawmakers who sponsored and supported the NFA repeal maintain that the tax imposition and the registration mandate were constitutionally and practically inseparable components of the original 1934 Act, a position that is now in direct conflict with the Justice Department, which is currently mounting a vigorous legal defense, arguing that the registration mandate retains independent constitutional validity even without the accompanying tax. Behind the scenes, federal agencies are exploring new fees that critics say look a lot like the old tax in disguise. Despite the congressional mandate to eliminate the tax, high-level officials within federal agencies are operating behind closed doors, reportedly examining and drafting proposals for new user fees, compliance charges, or administrative surcharges for NFA transfers, measures that critics are quick to denounce as thinly veiled attempts to reintroduce the financial barrier of the old tax under a different bureaucratic label. A counter-amendment now proposes the highest tax ever placed on a constitutional right in American history. In a deeply contentious response to the repeal, a dramatic counter-amendment has been formally proposed that seeks to impose a crippling fee structure, which, if passed, would instantly become the highest financial burden ever legislated upon the exercise of a constitutionally protected right in the history of the United States. Designed explicitly to make ownership of regulated firearms economically inaccessible to the vast majority of citizens. Buried inside a must-pass spending bill is a proposal that could reshape gun ownership nationwide. Crucially, a highly significant legislative proposal, one that carries the power to fundamentally alter the landscape of gun ownership across the nation, has been strategically inserted into a massive, must-pass spending bill, ensuring that its controversial nature is obscured and that its consideration will be rushed under the intense pressure of imminent government funding deadlines. The strategy is familiar: attach controversial policy to a shutdown deadline and force a last-minute choice. This aggressive legislative maneuver is the classic Washington tactic, deliberately attaching deeply controversial and transformative policy provisions to essential, high-stakes legislation that faces a rigid deadline, such as an impending government shutdown, thereby forcing opposing lawmakers into a difficult, last-minute Hobson's choice between sacrificing critical government funding or accepting the radical change. Federal judges are moving faster than usual, and that alone has Washington on edge. A remarkable and telling sign of the crisis's urgency is the visible acceleration in the federal courts, where judges are bypassing traditional scheduling and moving with unusual speed to hear and deliberate on the immediate legal challenges spawned by the tax repeal, a judicial rush that has severely intensified the nervousness and uncertainty gripping federal agencies and congressional leadership. The government is asking courts to wait, openly hoping Congress changes the law before judges rule. Recognizing the imminent threat of a judicial ruling that could invalidate the entire NFA registry, the Justice Department is now making extraordinary requests to the courts, openly pleading for delays in their decisions, a transparent admission that the executive branch is banking on Congress to legislate a fix, or a replacement measure, before a federal judge can issue a constitutional ruling that definitively strips the government of its regulatory authority. At stake isn't just future purchases, but millions of items already legally owned by Americans. The immediate legal battle extends far beyond the regulation of future firearm purchases. The core fight centers on the fate of millions of NFA-regulated items, suppressors, short-barreled rifles, and automatic weapons that Americans have already legally acquired and registered over the past 90 years, with the potential legal outcome threatening to redefine the status of all existing property under the Act. A retroactive tax provision could force gun owners to pay thousands or surrender property they bought years ago. One of the most concerning and contentious legislative proposals involves the creation of a retroactive tax provision, a measure that could legally compel current NFA owners to pay thousands of dollars in new fees or face the draconian choice of surrendering property they acquired and legally possessed for many years, creating a massive, politically explosive confrontation over vested property rights, billions in potential revenue, a national registry, and international data-sharing agreements all hang in the balance. The stakes in this unprecedented regulatory conflict are immense. balancing billions of dollars in potential revenue against the continued existence of the National NFA registry, a cornerstone federal enforcement, and threatening the viability of numerous international data sharing agreements related to firearms tracking and national security that are predicated on the integrity of that registry. What started as a tax repeal is now a high-stakes fight over power, precedent, and constitutional limits. The legislative action, which was initially presented as a narrow, technical repeal of an outdated tax measure, has quickly metastasized into a massive, high-stakes confrontation that transcends mere policy, evolving into a fundamental struggle over the limits of federal regulatory power, the binding nature of historical precedent, and the core constitutional limits of the Second Amendment itself. The next moves by Congress and the courts will determine whether this rollback becomes permanent or disappears quietly. All eyes are fixed on Washington, as the immediate, rapidly unfolding actions taken by congressional leaders seeking a legislative solution, coupled with the imminent judicial rulings emerging from the federal circuit courts, will conclusively and swiftly determine the fate of this historic firearms rollback, dictating whether this profound shift in federal policy becomes a permanent fixture of law or is successfully neutralized and disappears quietly from public view.